What happens when you don't respond to a subpoena in a criminal trial? Let's find out. Hi, folks. Tony DeWitt again with another video on the law. Remember, I don't dispense legal advice here, and this is what we're talking about today. Courts and lawyers do a number of things to preserve the appearance of a fair trial. Once the trial starts, witnesses are kept outside the courtroom until it is their turn to testify. Once they have testified, the court usually inquires as to whether or not the witness can be excused. Excused is an important term because if they are excused, that means they're not going to testify any further and they can sit in the courtroom and watch the trial if they want. Or they can go home, turn on court TV or Law and Crime and watch the trial if they prefer. However, if they are subject to recall, they cannot, and they must leave the courtroom and wait to be notified if they will at some point be recalled. This can be important when a witness serves some prosecution interest, but also serves some defense interest. And oftentimes, the defense is not going to want to get into what serves them on cross examination of the witness, but rather on direct examination in their case. And they do that because once the state rests and it's time for the defense case, the state is going to have a hard time responding to the testimony if they haven't been aware of what that testimony is going to be. And of course, the defense doesn't have to disclose that. But the main reason that you keep somebody out of the courtroom is you don't want witnesses sitting in there soaking up trial testimony from other witnesses and then regurgitating what those other people said during your testimony. Under the pretext, of course, that it's actually your recollection, when in fact you're just repeating what you heard some other witness say. Lawyers refer to this as the rule, and that's just the way it's referred to. The first time I heard that as a lawyer, I'm in there like, huh, what rule? It's a whole book of rules. I mean, we got 96 of them in the court in Missouri. What are you talking about here? But the rule is just basically you keep witnesses out, and it's really a good rule because it does prevent people bootstrapping their testimony on the basis of what other witnesses have said. In addition to this, there is always a concern about witness tampering. You don't want third parties connected either directly or indirectly to the case, either on the prosecution side or on the defense side, from going to witnesses and saying, hey, are you sure you remember it this way? Isn't it possible you could have seen it this way? It happens. It's witness tampering, but it happens in civil cases as well as criminal cases. So let me divert to a war story for a little bit. You know what the difference between a fairy tale and a war story is? A fairy tale starts off once upon a time, and a war story starts off, you're not going to believe this, but. Well, you're not going to believe this, but I had a case against a nursing home in St. Louis. It was a very fancy nursing home, had a great reputation, and it was supposed to give absolutely Cadillac care to the elderly people who were housed there. A nurse in that institution, knowing that the patient could not chew because she had no teeth and she had difficulty swallowing because of a stroke, gave her a pepperoni pizza to eat, or at least a piece of pepperoni pizza to eat. And the poor woman choked. Now, it didn't completely occlude her airway, but it made breathing so difficult that ultimately she had a heart attack and died. It upset one of the people who was caring for that woman, a nurse's aide, a lovely African American woman who was very kind and could not stand to see people treated badly. And so she went to the administration. They told her she didn't see anything. She filed a complaint with the Missouri Division of Aging. And in the complaint or the notice back to the nursing home that they'd had this complaint, it was pretty easy to figure out who had done that. So they got their lawyers involved, and the lawyer for the nursing home sat down with this woman and said, if you say anything other than you didn't see a thing when the people from the Division of Aging talked to you, You're never going to work in St. Louis ever again in the capacity of somebody doing healthcare. Now, this woman is not making megabucks doing this. She's probably making maybe 13, 14, $15 an hour. She was in her 60s at the time, and she was scared to death. So when the Division of Aging came and they asked her what happened, she claimed she didn't know. Couldn't recall any of the events that occurred that night, so the state dropped the inquiry at that point. Thereafter, she disappeared from the radar. She left that nursing home, most likely not of her own volition, and she couldn't be located. We asked a number of people to what her location was. We asked the nursing home, tell us where this woman went. We talked to a lot of the other nursing homes in the area. Nobody had a witness by that name. Nobody had an employee, I guess would be the better way to say that. Nobody had an employee by that name. So we wound up hiring a retired police detective to go find her. And when he did, he reported back to us that she had been threatened by the lawyer from the nursing home, the same lawyer who was representing the nursing home in the civil case. So we brought her in for a deposition. They didn't expect her to show. She showed, and as a result, she came and dished on everything that happened, how this nurse thought it was funny that the woman choked to death. And it was the kind of testimony that you dream of in a criminal case as well as in a civil case. In that particular civil case, it was a barn burner. It turned what was probably a $100,000 case into a very significant six-figure settlement with the nursing home. And that's the kind of thing that I think most people don't appreciate when they are trying to tamper with the evidence that's going to come in a case. If you get away with it, wow, you're a hero. But if you don't, and particularly as a lawyer, you can be charged with subornation of perjury. And in addition to that, you can be disciplined. Unfortunately, this lawyer was never disciplined for what he did. Once the case is in trial and you're trying to, round up witnesses, you don't want to have private meetings, and you certainly don't want, if you're the prosecution, somebody from the defense communicating with this witness about the facts of the case. These are important safeguards, and they're aimed at producing truthful testimony, not making it more difficult. One of the ways that you get witnesses to trial, particularly witnesses who don't want to be there in the first place, is through a subpoena. Subpoenas have the force of law. They're not a friendly request to come to court. They're an order to come to court, and if properly done, you can order them to bring documents and other things with them to court. Now, witnesses can file to quash a subpoena, and many times corporate defendants do that, but only if they know what to do. And so if you have a lay witness who doesn't know that you can move to quash a subpoena, most of the time they just show up and testify. Most don't really mind coming in and telling what they know, but people do forget, and that's what happened to a witness in the Sturmer trial. She forgot she had been subpoenaed for the March 31st date because she got a subpoena from the defense for April 7th. When the witness didn't show up on the 31st, as she should have, the prosecution asked the court to issue a bench warrant, and the court did. But what actually happened here is she contacted the sheriff's office. The sheriff's office went out and got her, brought her to court. She came into court, and that's when she found out she was going to spend some time in jail. Now, in most cases, they don't really spend time in jail. They kind of walk them through the jail, do all the stuff that goes with becoming somebody who is in jail, but then they're offered a chance to bond out. So they usually demand a cash bond, and that cash bond is something that they're going to put in out of their own pocket. Essentially, a surety, which means a bondsman, is not going to be able to help them. They're going to have to come up with $500 cash or $1,000 cash in order to get out of jail. Well, now they've got $1,000 in the registry of the court, and they know that if they don't come to court, they are going to be losing that bond, forfeiting that bond. They tend to show up. In a civil case, at least in Missouri, instead of an arrest for indirect contempt, which is what happened here, courts will issue what's called a body attachment, which is essentially the same thing. They're brought to the jail, made to post bond, and then usually they show up to testify, but not always in the way you want. somebody who had to shell out $1,000 out of their pocket to testify in a case is likely to be just a little bit hostile to you when they take the witness stand. But at any rate, the arrest of a non-compliant witness is what we have happening here. The witness presents herself at court, explains why she didn't come, and I think she honestly didn't know she was needed because she got 2 subpoenas, one from the state and one from the defense. But let's watch this little interaction with the judge here.
Okay, you messaged one of them, or?
Yeah,
Okay.
yeah.
Counsel, since you happen to be here, defense counsel, Mr. Mueller, since you happen to be here, she's indicating she messaged you or Mr.
Not
Kelly?
Art. I think I talked to him on Messenger.
Art?
Yeah.
Oh, there you go. Linda's significant other.
Oh, okay.
So then I called that's when I emailed this morning. I called or found out. So I seen it online. I looked at it.
Okay. Okay. Are you on anyone's probation or parole right now?
No.
No? Okay. Anyone wish to be heard on,
Well, first of all, I have a concern about the defendant's significant other communicating with witnesses in this case. He's not a party, he's not an attorney, he's not an investigator, he's a significant other, so that caused me grave concern here, Your Honor.
well, who contacted who?
I reached out to them.
How did you find?
I think go ahead. I think it was me that did it. I don't remember. I'd have to look at my phone and tell you for sure because to me this wasn't really like that big, that significant. I think it was me that reached out to him. I don't remember. I'd have to look.
Do you know them personally, or?
Well, I mean,
Maybe.
right, but I had heard that the trial was going on and stuff. So.
But I want to know how she knows Ms. Sturmer's new significant other, because they were neighbors in 2007.
No, but I talked to him plenty of times on Messenger. Previous I think it was 2019 and 20. I talked to Linda and Art previously and like a long time ago.
Okay, some giant red flags are waving now on the prosecution side because you have Sturmer's new boyfriend, which is kind of odd. You wouldn't think of someone who sort of, if the allegations are true, burned up her husband would be necessarily someone who would be out there in the dating pool doing well. But at any rate, he is her significant other, and this woman contacted him as opposed to going to the lawyers. And that's because she had a fairly long period of time prior to this trial going on where she had communicated with this guy, which obviously looks pretty skeevy to the people who are in the prosecution here.
How'd you get here today?
The deputy?
Deputy brought you? Okay. Okay, anyone wish to be heard?
Well, first of all, I'm going to ask the court to prohibit this individual from having any contact with the people's witnesses. He's not an attorney. He's not a private investigator. He should have no reason to speak with anyone. And if he wants to play lawyer, he can go to law school. If he wants to play private investigator, he can get his license. So this is extremely disturbing and frightening that this individual is having contact with our witnesses. Especially since there's no reports ever being prepared, there's no discovery of any of these conversations being provided. I'm very upset by this, Your Honor, and I'm kind of holding back as much as I can here because this is very frustrating.
I can appreciate his being upset by this because he really ought to have copies of the messenger messages that have flown back and forth between Art and this woman, but my guess is he's going to have a lot of trouble getting those. And so I understand his objection, but I do sort of like the way the defense responds to this.
Position?
Yeah, right, showboating right now, first of all.
Takes one to know one, sir.
Second of all, she inquired about Linda Sturmer's well-being. They were friends and neighbors for years. There's nothing wrong with that. And in terms of anybody reaching out to anybody, it came from the witness to our side. So there's no issue here.
Well, counsel, that's not exactly true because you can say that because it's unlikely that the state's ever going to get those messages, but how do we really know what the content was of those messages? He's just saying what he thinks to be true. He has no way of knowing whether or not that's actual or not. And he ought to be even more upset with Art than is the prosecution. This could be a major issue in the case, and it probably shouldn't be. And the lawyer should have told Art to keep his nose out of this business. And Art should have said to this woman when he contacted her, or when she contacted him, he should have said, call the lawyers. Here's their number. That's all he should have done. So now we get to logistics, and this becomes interesting.
Your Honor, I would also inquire if she has reliable transportation.
I don't. No.
And I would say for the record, Your Honor, I wasn't paying attention, frankly, when she was talking about reaching out to somebody. I don't know when that happened. I contacted Ms. Calhoun a week and a half ago. She hadn't been served. I just wanted to know, have you been served? Are you going to come? So I have to subpoena you. And do you remember what you said in your affidavit? Because I'm going to ask you questions about it. So that's the only and I don't know if she's confusing Mr. Bean with me, but that's my contact.
Ms. Calhoun, do you have any controlled substances in your system now?
No, I don't. No.
Methamphetamine by chance?
No.
Okay, what I'm gonna do is I am gonna set this matter for a status conference for Tuesday. Say 1 o'clock, do you think you can get her on the stand?
I could try to make adjustments so that she could be on the stand.
Okay. I'll set the matter for Tuesday at 1 o'clock for a status conference. And ma'am, due to your failure to appear here, I am concerned at this time about non-appearance when I hear about the transportation issues as well, so I am gonna set a bond.
Okay. I have, my brother lives in Lawrence. I can live or stay in Lawrence.
Okay.
That's okay.
Well, for now, I'm gonna set bond. I'm gonna make it $1,000 cash or surety.
Oh my gosh.
Okay. To make sure that you show for the year on time for your under your subpoena. Sounds like both sides were inquiring about using you and you didn't show.
It wasn't because I was unaware that I was needed, right? I mean, like, honestly, I've had some stuff going on in my life that I didn't even, like, my own problems.
Okay.
You know, not that this
Yeah.
isn't a big problem, but my own issues, like serious issues. And I wouldn't just miss something because I didn't want to be disrespectful or just because I was being disrespectful to the court. I had no idea.
Whether this is the witness's version of I didn't know the gun was loaded or what, it certainly sounds legitimate to me. I mean, I think she's honestly telling the truth here that she just didn't know she had to be there or wasn't, aware that she was due on that particular date. But it gets worse. The judge thinks she's under the influence of something. She's going to order drug testing when she gets to the jail, which should be interesting. And in addition to that, she sets the $1,000 bond, and it just really sets this woman off.
Okay.
Over somebody else's problems. My own life and my own problems.
Okay. Ma'am, I'm gonna have you tested at the jail, okay? Anything else, anyone? Ma'am, if you do post that bond, okay. If you're able to post the bond either directly or through other people, you need to report back here on April 1st at 1 o'clock, okay?
I don't have a car.
Okay.
I feel compassion for this witness, and I think it's clearly an oversight. And I would point out that I have missed court dates. I mean, I wasn't subject to subpoena, but I was supposed to appear in Callaway County one time, and it didn't wind up on my calendar. And so I was blissfully working on a brief when the court called and said, "Where are you?" And I said, well, honestly, Judge, I forgot. And I got a little bit of a lecture. It wasn't too bad, a little bit of a lecture. And so I asked when the case was going to be reset, and he said, "It isn't. I granted your motion." So even though I didn't show up, I won. I'm sure that frustrated the dickens out of the defense counsel in that case. But sometimes the fact of the matter is being honest can work for you. In this case, I think this judge does not have a good grip on her judicial discretion at this point. I think the proper thing to have done, what I would have done if I'd been the judge in that case, is I've said, "Okay, I'm gonna ask you to post $250 bond. And that would be so that you go to your brother's house in Lawrenceville and then he brings you back here. I want your assurance that that's going to happen. And then I will, allow you to post a much smaller bond. I just don't think that there is something about the way this judge operates that leads me to believe she hasn't been a judge very long. But at any rate, I thought this was interesting, the fact that the woman did not show up and what the remedy for that was. Thank you very much for being here. Hope you've enjoyed this. Catch me down here at the beach again tomorrow. Thanks for watching my video. If you have a request for me to cover a topic, please send me an email to the address above, and in the subject line put video request. If you have comments, drop them in the comments down below. If you found the content worthy, please consider subscribing. Since I started doing this work, I have always asked listeners to consider doing just one kind thing every day to make somebody else smile or make their life better in some way. Please consider doing that. It makes the world a better place. Now, YouTube has some suggestions for other videos of mine you may find interesting.